Hi, this is Mike Maslanka. Here's an employment law prediction for 2017. Sexual orientation will become a protected classification under Title VII of the Civil Rights Act of 1964. That's right. A law passed over 50 years ago, when homosexuality was a violation of the law in many states, will be found to protect gay employees from discrimination. One case from a federal district court in Pennsylvania is on board with the idea, and the entire Seventh Circuit Court of Appeals up in Chicago is currently considering whether to join the parade. Let's talk about the facts in the Pennsylvania case in order to understand the argument being made. A male employee works in a call center. He has a male partner. The employee's supervisor makes vulgar comments to him about the sexual practices of gays. The supervisor says that gays allegedly are not fit to work in a call center, and he calls the employee by various derogatory names for gays. The employee goes to the EEOC, that's the Equal Employment Opportunity Commission, and the commission takes up his cause. Its argument is like a three-legged stool. Here's the first leg. Roll back to 1989 and the adoption by the United States Supreme Court of the theory of sexual stereotyping. The court reasoned that not promoting a woman to partner because she did not act sufficiently male stated a claim for sex discrimination under Title VII. Now here's the second leg. Let's fast forward to 1998 to another Supreme Court case that found that same-sex sexual harassment violated Title VII. The employer in that case argued, but surely Congress could not have contemplated such a holding way back in 1964 when they passed the law. But in the prophetic words from Justice Scalia, who wrote the majority opinion, statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils. Here's the third leg. Some courts hold that an employee certainly cannot be punished for converting from, say, Christianity to Buddhism, any more than an employee should be punished for transgendering from a man to a woman or from a woman to a man. The common thread in all three arguments is that something bad happened to an employee because of sex. Same here. The employee in the Pennsylvania case would not have been treated the way he was had he been a woman. The adverse actions, therefore, were because of his sex. Two final thoughts. The beauty of the common law is in its inherent ability to organically evolve and adapt. An ancient Greek philosopher wrote, "No one ever steps into the same river twice." That's the common law. And second, as I tell my students when I teach employment law, we will be studying the scaffolding of the employment law, burdens of proof, relevant evidence, quantum of damages, and much more. But I ask them never to forget that the scaffolding of the law has a purpose, and that singular purpose is to treat human beings as individuals who rise or fall on their own merit with an occasional helping hand. We'll see what 2017 brings. This is Mike Maslanka at your desk.